4. To discharge or otherwise discriminate against an employee because he has filed charges or given testimony under this Act. 5. To refuse to bargain collectively with the representatives of his employees, subject to the provisions of Section 9(a), (b). It shall be an unfair labor practice for a labor organization or its agents. 1. To restrain or coerce employees in the exercise of the rights guaranteed in Section 7, provided that this paragraph shall not impair the right of a labor organization to prescribe its own rules with respect to the acquisition or retention of membership therein, or b. An employer in the selection of his representatives for the purposes of collective bargaining or the adjustment of grievances. 2. To cause or attempt to cause an employer to discriminate against an employee in violation of subsection A(3), or to discriminate against an employee with respect to whom membership in such organization has been denied or terminated on some ground other than his failure to tender the periodic dues and the initiation fees uniformly required as a condition of acquiring or retaining membership. 3. To refuse to bargain collectively with an employer, provided it is the representative of his employees subject to the provisions of Section 9(a). 4. To engage in, or to induce or encourage any individual employed by any person engaged in commerce, or in an industry affecting commerce, to engage in a strike or a refusal, in the course of his employment to use, manufacture, process, transport, or otherwise handle, or work on any goods, articles, materials, or commodities, or to perform any services, or to threaten, coerce, or restrain any person engaged in commerce, or in an industry affecting commerce, where in either case an object thereof is forcing or requiring any employer or self-employed person to join any labor or employer organization, or to enter into any agreement which is prohibited by Section 8(e). B. Forcing or requiring any person to cease using, selling, handling, transporting, or otherwise dealing in the products of any other producer, processor, or manufacturer, or to cease doing business with any other person, or forcing or requiring any other employer to recognize or bargain with a labor organization as the representative of his employees, unless such labor organization has been certified as the representative of such employees under the provisions of Section 9. Provided that nothing contained in this clause b. shall be construed to make unlawful, where not otherwise unlawful, any primary strike or primary picketing. C. Forcing or requiring any employer to recognize or bargain with a particular labor organization as the representative of his employees, if another labor organization has been certified as the representative of such employees under the provisions of Section 9. D. Forcing or requiring any employer to assign particular work to employees in a particular labor organization, or in a particular trade, craft, or class rather than to employees in another labor organization, or in another trade, craft, or class, unless such employer is failing to conform to an order or certification of the board determining the bargaining representative for employees performing such work. Provided that nothing contained in this subsection b. shall be construed to make unlawful a refusal by any person to enter upon the premises of any employer other than his own employer, if the employees of such employer are engaged in a strike ratified or approved by a representative of such employees, whom such employer is required to recognize under this Act, provided further that, for the purposes of this paragraph 4 only, nothing contained in such paragraph shall be construed to prohibit publicity other than picketing, for the purpose of truthfully advising the public, including consumers and members of a labor organization, that a product or products are produced by an employer with whom the labor organization has a primary dispute and are distributed by another employer, as long as such publicity does not have an effect of inducing any individual employed by any person other than the primary employer, in the course of his employment, to refuse to pick up, deliver, or transport any goods, or not to perform any services at the establishment of the employer engaged in such distribution. 5. To require of employees covered by an agreement authorized under subsection A(3) the payment, as a condition precedent to becoming a member of such organization, of a fee, in an amount which the board finds excessive or discriminatory under all the circumstances. In making such a finding, the board shall consider among other relevant factors, the practices and customs of labor organizations in the particular industry and the wages currently paid to the employees affected. 6. To cause or attempt to cause an employer to pay or deliver, or agree to pay or deliver any money, or other thing of value, in the nature of an exaction, for services which are not performed, or not to be performed, and 7. To picket or cause to be picketed, or threaten to picket or cause to be picketed, any employer, where an object thereof is forcing or requiring an employer to recognize or bargain with a labor organization as the representative of his employees, or forcing or requiring the employees of an employer to accept or select such labor organization as their collective bargaining representative, unless such labor organization is currently certified as the representative of such employees. A. Where the employer has lawfully recognized in accordance with this Act any other labor organization and a question concerning representation may not appropriately be raised under Section 9(c) of this Act. B. Where within the preceding 12 months a valid election under Section 9(c) of this Act has been conducted, or C. Where such picketing has been conducted without a petition under Section 9(c) being filed within a reasonable period of time not to exceed 30 days from the commencement of such picketing, provided that, when such a petition has been filed, the Board shall forthwith, without regard to the provisions of Section 9(c) 1, or the absence of a showing of a substantial interest on the part of the labor organization, direct an election in such unit as the Board finds to be appropriate, and shall certify the results thereof, provided further that nothing in this subparagraph C shall be construed to prohibit any picketing or other publicity for the purpose of truthfully advising the public, including consumers, that an employer does not employ members of or have a contract with a labor organization, unless an effect of such picketing is to induce any individual employed by any other person in the course of his employment not to pick up, deliver or transport any goods, or not to perform any services. Nothing in this paragraph 7 shall be construed to permit any act which would otherwise be an unfair labor practice under this Section 8(b). C. The expressing of any views, argument, or opinion, or the dissemination thereof, whether in written, printed, graphic, or visual form, shall not constitute or be evidence of an unfair labor practice under any of the provisions of this Act, if such expression contains no threat of reprisal or force or promise of benefit. D. For the purposes of this section, to bargain collectively is the performance of the mutual obligation of the employer and the representative of the employees to meet at reasonable times, and confer in good faith with respect to wages, hours, and other terms and conditions of employment, or the negotiation of an agreement, or any question arising thereunder, and the execution of a written contract incorporating any agreement reached, if requested by either party. But such obligation does not compel either party to agree to a proposal, or require the making of a concession, provided that, where there is in effect a collective bargaining contract covering employees in an industry affecting commerce, the duty to bargain collectively shall also mean that no party to such contract shall terminate or modify such contract, unless the party desiring such termination or modification 1. Serves a written notice upon the other party to the contract of the proposed termination or modification 60 days prior to the expiration date thereof, or in the event such contract contains no expiration date, 60 days prior to the time it is proposed to make such termination or modification. 2. Offers to meet and confer with the other party for the purpose of negotiating a new contract or a contract containing the proposed modifications. 3. Notifies the Federal Mediation and Conciliation Service within 30 days after such notice of the existence of a dispute, and simultaneously therewith notifies any state or territorial agency established to mediate and conciliate disputes within the state or territory where the dispute occurred, provided no agreement has been reached by that time, and